Thank you for joining Seyfarth's webinar, New Jersey Temporary Workers Bill and its Impact on the Staffing Industry. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Rob Sibba. Rob, you may begin.
Wonderful. Thank you very much. Thank you to everyone who's attending today and our participants for today's presentation. We're very excited to bring to you a discussion about the New Jersey Temporary Workers Bill of Rights and its impact on the staffing industry. Next slide, please. So just as a starting point and to level set a little bit, today's presentation is for informational purposes only. The information discussed during the webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances, and the content is intended for general information purposes only. You are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. I'd like to start off today by introducing our speakers today. With us today, next slide, please. We have one of our budding associates, Nick Lucier, who's going to talk to us about various issues on the law. We have myself, who's going to talk about a few of the notice provisions and other requirements under the law. And then Ben Conley and Marlon Duro Martinez, we're going to address some of the benefits issues and paid sick leave issues, respectively, under this new New Jersey law. Next slide, please.
Hi, everyone. As Rob mentioned, my name is Nick Lucier, and I am one of the people here at Seyfarth that have been involved in tracking this law for some time. I just wanted to briefly give a history of the legislation and what New Jersey has done as far as regulating this industry. It started about 130 years ago when New Jersey started regulating sort of what it categorized as abuses within the temporary staffing industry. And specifically, it turned a regulatory framework over to municipalities to actually regulate the staffing industry, but they found that it wasn't really working so well. So what they did was they took power back from the municipalities and they brought it under the auspices of the state government, some of the administrative agencies that have been created in the New Deal process, and started regulating from the state level. In the mid-1900s, there was sort of another consolidation effort under the state government. The modern framework came into being, and we got something that sort of resembles what we see today. Nothing quite like the New Jersey Temporary Worker Bill of Rights, but nonetheless, something a little more modern. And then finally, as we know, on February 6, 2023, New Jersey enacted the Temporary Worker Bill of Rights. So I wanted to just sort of highlight this quote. By now, I'm sure some of us are familiar with Senator Joseph Cryan. Senator Cryan was the principal sponsor of this, or the primary sponsor, excuse me, of the Temporary Worker Bill of Rights. And I think this quote sort of describes a little bit of what the thought was behind the law and where they, thought they were going to go with it. I pulled it from one of his interviews. He's given several interviews about this law online. I encourage you all to take a look, give them a watch, because I think they are somewhat insightful. But as he describes in this quote, the law was aimed at protecting low-wage industrial warehouse workers. It wasn't supposed to be for office positions, people who were filling in during tax season. It was really aimed at people that the New Jersey government, the New Jersey Department of Labor, sort of classically categorized as exploitable. And so just to get to the substance of the law now, I want to talk about who it applies to, who is covered, who needs to be aware of the provisions. So a temporary help service firm as we know, is any person or business or entity operating a business who employs individuals directly or indirectly for the purpose of assigning the employed individuals to assist the firm's customers in the handling of customers' temporary, excess, or special workloads. I'm sure a lot of us have sort of looked at the temporary, excess, or special workload language and tried to figure out exactly what those words mean. I want to just point out that that language has been around for decades at this point. There's been case law that has mentioned that, has sought to define those words. And so there is some instruction on what those words mean. But I also want to point out with respect to the word temporary, Senator Cryan was actually quite specific when he was talking about the bill in various interviews. And he said one of his main concerns about temporary staffing agencies and what they were doing previous to the Temporary Worker Bill of Rights enactment was they were using permatemps. It's not exactly clear what he meant by permatemps, but for all intents and purposes, it seems that what he was saying was it was people who would be consistently employed or consistently brought back to a third-party client, and it wasn't exactly clear when they would actually stop working for that client. And so you look at the definition and you think, well, how does that fit in with the word temporary? Well, it would seem that for at least with respect to permatemps, excess or special, the latter part of that provision is going to be having to do most of the work here. And then we also have, in addition to payment of wages or salaries to employed individuals, pays federal Social Security taxes and state federal unemployment insurance. And moving on to the next slide. Let's see, sorry, it looks like we have next slide. There we go. Carries workers' compensation insurance as required by state law, sustains responsibility for the actions of the employed individuals while they render services to the firm's customers. It doesn't really describe exactly how contractual relationships between a third-party client and the temporary help service firm may shift responsibility from one entity to the other, and how this might impact the definition and whether someone constitutes a temporary help service firm under the law. So that's definitely something to keep in mind as well as we look for further guidance and regulation from the New Jersey Department of Labor. And as I pointed out, the larger definition of temporary help service firm is something that dates back decades. There are people, and we've seen questions about this where they didn't know, or they were told or whatever that they did not constitute a temporary help service firm before the law was enacted, and now all of a sudden they have a question, well, what about now? This definition has been around forever, so do we have to do it now? And those questions tend to be very fact specific, but if you have a question about that, please feel free to reach out. Now, as a quote from Senator Cryan indicated earlier, the law does not cover all jobs. The law only applies to designated classification placements and certain occupational categories as defined by the Bureau of Labor Statistics. So there are 23 major classifications within the Bureau of Labor Statistics standard of classification. This law includes 9 technically, so under half of the total number of classifications. What I want people to be aware of, though, is that all of the 9 classifications have sub-classifications. So if we look, at other protective service workers, which is actually a sub-classification, that's why I said technically before. Within that subclass, there are additional jobs with definitions and a list of job duties and sub-classifications. So security guards, gambling officers, lifeguards, protective service workers, all other, more on that later. These are all under that sub-classification, so you should be aware of these. But bringing back the whole list, you will notice that many of these positions are industrial or service oriented. Like I said, some of these jobs are those that the New Jersey Department of Labor views as classically exploitable positions. And just quickly, don't feel like you need to read every word on this slide, but I want to point out some of the weak spots in the Bureau of Labor Statistics standard of classification. And I only want to point out that the standard of classification was not built for this. It was made to be a statistical tool, and it cautions actually against the use in an administrative or regulatory or tax program. There are certain principles you should be aware of, namely job duties take precedence over job titles. So what you're actually doing is what they're concerned about. Also, if there's overlap between two job titles, workers should be coded into the job that requires the higher degree of skill. Given that the law seeks to protect lower skilled individuals, generally speaking, it is possible that including a broader set of job responsibilities will actually move the worker from being, say, a covered position into a non-covered position. So where do these principles come from? So the standard of classification, so the Bureau of Labor Statistics has a manual. That manual is 285 pages. And I'll say that again, it's 285 pages. It is dense. We are not sure if the New Jersey legislature intended to incorporate these principles, but we can only assume they did because they included it in the law. So I want to do a little bit of a context-driven analysis on the IT worker. So an IT worker can fall under numerous categories under the law. And there's two here shown. One is a covered position, that's the one at the top, and one is at the bottom, and there's another one at the bottom that's not covered. So it would not be a designated placement, a designated classification. So if we look though at the definitions below that, at the definition below the classifications, what you'll see is there's like quite a bit of overlap between the two. So we have repair, maintain, word processing systems for the covered position, and then we have provide assistance with respect to word processing systems and the not covered position. So if you look, it actually seems like what is going to turn on, coverage or not, could turn on maintaining versus providing assistance on word processing systems. Now, of course, you may say that maintaining and providing assistance could be synonymous in this circumstance. So this is why I'm trying to get through was that this is a context-driven analysis. You really have to look at the job descriptions, what they're actually doing on the job, and really evaluate whether or not they fit into one category or another. As mentioned earlier, the law also includes some all other categories, and these are relatively unhelpful classifications in the Bureau of Labor Statistics. Again, it wasn't made for this. And the all other subclassifications, like this one shown for protective service workers, have definitions below or included that will try to lend some insight into exactly what they mean. But as this one shows for protective service workers, frankly, not very helpful. All protective service workers not listed separately doesn't really give you much insight into who exactly might be covered. And frankly, there are others included in the law as well, not just protective service workers, but you have all other personal care, all other production, all other material moving workers. And again, the definitions are not very helpful. I will note that if you go to the 2018 version of the standard occupation classification system, they have illustrative examples included, and those can help get a little more insight, but they only provide about 3 to 4 examples per all other classifications. So it doesn't provide full insight, and it may not answer your question fully. So as of right now, who's in and who's out, I wanted to give a helpful list of the kind of positions that we're seeing. So security guards are in, as we talked about, dishwashers, machinist welders, they're also in. People who are out are like standard office workers, secretaries, administrative assistants, financial clerks, data entry workers. Those positions are out of the law for now. And I say for now because the the Bureau of Labor Statistics frequently updates the standard, or periodically updates the standard occupational classifications. I think the last time they did a full one was in 2018, but you'll see every month they reissue it because, once again, it's a statistical model that they use to track wages and things. So those are actually updated every month. But that's all for me right now. I'm going to turn it over to Rob, who's going to discuss the notice provisions of the law.
Absolutely. Thank you so much, Nick. Let's go to the next slide. One of the key features of this law, among others, is the robust notice provisions that temporary service firms are obligated to comply with. So One of the things that's interesting about this law is that the Department of Worker and Workforce Development has actually developed a form to convey notice to workers that are being placed. So let's talk a little bit about what this form requires. First and foremost, the important thing to note is that the firm has to dispatch notice at the time of a placement in a manner that's sort of consistent or appropriate for the type of placement. So, for example, if you have a worker that's coming in person onto the facility or into the temporary service from office, a face-to-face, handing of the notice may be appropriate. Alternately, remotely via text or email or electronic exchange or something like that would be appropriate. Another important caveat about this notice is that I believe the Department of Labor has issued a form notice, but the obligation also extends to provide notice in whatever the primary language of that employee might be. So that form may need to be translated into any other type of native language that the worker speaks in order for it to be understandable for the worker. Now let's talk about some of the other contents of what that notice entails. Next slide, please. So that notice will have to also address the name of the temporary worker, the name and address and telephone number, effectively the contact information of the employer, of the temporary service firm, and whoever the contact agent is that's facilitating the placement, so a human individual that's coordinating this. The workers' compensation carrier, so if there is any type of workplace injury or incident that the temporary employee needs to report, that information is provided, as well as the work site of the employer or third-party client, and information about contacting the Department of Labor and Workforce Development. So basically, contact information for these effectively four stakeholders that the temporary employee might need to get in touch with at some point. Additionally, the notice has to include the name and nature of the work to be performed, as well as a description of the position and whether or not it will require specialized training or equipment. So that may extend beyond the job title as well into the type of duties that will be performed, whether the worker needs to operate or bring with them any type of equipment or have any type of training that is required. Next slide, please. The notice also has to talk about some of the compensation information. So, for example, the wages that are going to be paid for the job, the name and address of the assigned work site, so the actual physical location, not just the contact information for the employer, but the actual physical location of the job site itself. The terms of transportation and meals offered to the temporary laborer, if applicable, and the costs associated with that. So we're going to talk about that in a second when it comes to deductions, but you'll notice that the actual document has to explain what the transportation situation is for the placement, as well as if there's any meals that are available for purchase or if whatever the arrangements are. Additionally, the notice has to address the length of the assignment, so how long will the worker be assigned to that location, as well as the amount of sick leave that they're offered. So we're going to talk about sick leave. Our colleague Marlon is going to address that in a few minutes. That all has to be included in the notice. Next slide, please. So one of the big questions that is coming up, the law is designed to apply, as the name would imply, as being the New Jersey Workers' Bill of Rights, Temporary Workers' Bill of Rights, to New Jersey temporary workers. One of the questions that has come up, especially because of the geographic placement of New Jersey being between New York and Pennsylvania, New York City and Philadelphia being the two major cities, there's a lot of commerce that happens with workers from the state of New Jersey being placed in other states, workers from other states being in New Jersey, like I said, because of the geography, and there's a lot of transmittal between the neighboring states and New Jersey itself. And the question that has come up is, does a temporary help service firm that's dispatching a worker into New York or into New York-based clients, do they have to give that worker notice? And next slide, please. effectively, the answer is yes. So if a firm that is operating in New Jersey is dispatching workers really anywhere in the world, because we'll talk about the statutory text later to kind of flesh this out, it's not so much where the placement is taking place, so much as it is the temporary service firm that is operating in New Jersey and sending workers to work locations that is the crux of the analysis. Next slide, please. Another question that is coming up quite a bit recently also is New Jersey taking the stance that record-keeping provisions applicable to third-party clients are enforceable against New York or out-of-state based employers? Next slide, please. Unfortunately, unlike the prior very clear and explicit slide, it is a little bit unclear as to what the answer would be, because ultimately there are some issues in terms of jurisdiction, enforceability, the constitutionality of extraterritorial application of some of these laws. There's been litigation that's filed in the District of New Jersey by some of the trade associations, for example, the New Jersey Business Industry Association, the American Staffing Association, that challenges various aspects of this law, including some of the jurisdictional questions that have arisen as a result of these multi-state transactions that are being engaged in. Next slide, please. Some of the other questions that are coming up, and these have a little bit more of a clear answer. For example, temporary staffing agencies must comply with all of the requirements of this law with regard to temporary workers who assigned to third-party clients. And here we say New York, but really out of state. So if it's whether it's New York or any other state, these requirements must be met with respect to each of these placements. Ultimately, as I noted before, the crux of the analysis is whether or not the temporary staffing agency is located, operates, or transacts business in New Jersey. Now, some of those words are a little bit debatable as to whether or not some firm is located in New York or in New Jersey. Maybe explainable if they have an office, but whether somebody operates or transacts business, especially in this remote work environment, is a little bit more of a fact-specific analysis. Now, the other thing to point out is that requirements of this new law are triggered at various stages of the relationship between the temporary service firm and the temporary worker, really without any regard as to where the state of the performance is. So these notice provisions and some of the other provisions as to withholdings, deductions, the notice that has to happen subsequently, if any of those, if any of the information on that initial notice changes, if any of those things trigger a new notice requirement or new obligation, there really is there's no limitation just based on the sheer geography of where the worker is and where that is happening. Next slide, please. Another aspect of this law that's important to note is that whenever a temporary service firm agrees to send a person in a designated classification placement, the firm shall provide the temporary worker at the time of dispatch a statement of the following items approved by the commissioner. So again, that highlights the fact that there is a form that is provided. There is very specific information that must be given to anybody who's being placed at a temporary work site. And to reiterate, to point out, the law does not say that the work has to be performed in New Jersey. So really, it is multi-jurisdictional. Really can happen anywhere. Next slide, please. A key feature of this law also the prohibitions on deductions. So explicitly in the law, there is a prohibition on deductions with regard to transportation. Going back to the notice provision, transportation is one of the things that has to be addressed. So, for example, the law requires that if transportation is provided, transportation to the work site being provided, then there has to be a corollary of transportation being provided from the work site back to where the worker was originally picked up. If the worker is going to be taking, for example, some sort of provided transportation, there is joint and several liability for whatever happens during transit, unless that transportation happens by common carrier or New Jersey Transit or some other public utility. This Charging back for transportation also wouldn't apply if the worker is taking their own transportation or getting themselves to wherever they need to be via their own vehicle. But just to address the deduction element, there's a prohibition on charging the employee back for providing transportation to the work site. Similarly, from time to time, temporary service agencies perform background checks. I would say from time to time is perhaps understating it. I think that happens more often than not. But a background check, a criminal background check, drug testing, any of these things that must take place, whether it's for purposes of being placed onto the roster of available talent, or whether it's being placed at a certain placement, the worker, it's prohibited from charging back the worker for the cost of that testing, the background check, or any costs associated with that. Those two items, transportation and background checks, are explicitly referenced in the law as prohibited deductions from the employee. Now, what is permitted is if the employee is consuming meals. Now, I use the word consuming intentionally. The law does require that a meal that is charged back, it hinges on whether it is consumed. So it is theoretically, the law prohibits a deduction for a meal that the employee does not have a chance to consume, but meals are permitted. Any equipment is permitted as well at fair market value. If any equipment is charged back, if the equipment is not returned by the employee, the company is allowed to charge back for the cost so long as the employee agrees to that at the time that the deduction is made. So hypothetically, if an employee fails to return a piece of equipment or some sort of tools or anything like that, they would have to provide a written authorization for the deduction in lieu of bringing back that equipment. Now, the total amount of deducted meals and equipment cannot place the employee in a position where their pay falls below the state or federal minimum wage, which the comment of whichever is greater is inevitably would be the state minimum wage. But those deductions cannot put the employee into the position where they're making less than minimum wage. So that is the floor or ceiling, if you will, to any deductions that are being made. The other important thing is there are a lot of record-keeping provisions. There is a 6-year statute of limitations. So these record-keeping provisions really track that time frame. Anytime that there is any type of chargeback or deduction or anything like that that happens, it is encouraged to keep any type of written record of what that is down to, the receipts or any other corroboration, not just the actual chargeback that is happening on the pay statement or on any other type of notice that's given to the employee. Next slide, please. Now, one of the key provisions to this law that has made a lot of headlines really is the pay equity provision. So we've talked a little bit about the notice, we've talked a little bit about the deductions. Those aspects of the law really are very robust protections, but this may be one of the key and most noteworthy provisions. So effectively what the law requires is that any temporary worker that is being placed is supposed to be paid at an equivalent rate to any employee, any permanent employee of the same third-party client that works in a substantially similar work with a substantially equal skill, effort, or responsibility and similar working conditions at the time that placement is happening. Now, what's really important about this provision is we see this type of language in a lot of other pay equity laws, including New Jersey's and the federal law, and they use the verbiage of substantially similar, equal skill, effort, and responsibility. These phrasings are intentionally intended to be broad, and in order to capture a greater net or a greater pool of equivalent jobs. So, for example, if somebody is coming in as a temporary worker and does not have exactly the same responsibilities as a full-time permanent employee, that may still put them into this dynamic of doing substantially similar work or arguably substantially similar work, and thus require similar, the same pay that they would be making if they were a permanent placement. The important thing to remember, though, is that it's whatever the worker is being paid. So, for example, it's not charging the third-party client what they would be paying a permanent worker. It's paying the temporary worker, what they would be earning if they were a permanent employee of the third-party client. That is like I said, a very key aspect of the law, because it really is intended. And we've heard from Governor Murphy, and we've heard from a variety of folks within the New Jersey government about the intention of this law, and it really is to put temporary workers effectively, as it impacts them, on the same footing as if they were hired permanently by any of these employers. And the important thing to note is that, anytime there's a violation, there is a civil penalty of $5,000 for each violation that is determined. That number does not necessarily include any of the other things and civil remedies that are available to workers. That in and of itself just addresses this pay equity concept. Now, it is sometimes not so easily determined as to what these substantially similar, equal skill, effort, and responsibility analyses are, how they shake out without really a very fact-specific analysis. And I think that there's going to be a little bit more, a little bit more of a careful, analysis and thought being given to the types of placements and the types of duties, responsibilities that temporary workers have at the variety of placements that they are being placed into. Next slide, please. As noted, the key things, the key phrasing here, same or substantially similar work, equal skill, similar working conditions. From our perspective, seeing these types of cases in the equal pay context, and borrowing a little bit from that analysis, this is really where a lot of litigation is focused on, is the dispute as to whether something is the same or substantially similar, whether it requires equal skill. This is the type of language that we've seen in that litigation, both at the federal level, to some extent at the New Jersey level, under different statutes, and we expect that to sort of inform what's going to happen when enforcement begins with a lot of these provisions and litigation begins with a lot of these provisions. Next slide, please. Now, one of the things to also keep in mind is the penalties section and what the penalties provide for in this law. One of the other critical things about this law that is extremely challenging and noteworthy is that the law provides for joint and several liability for permanent placements with respect to wage requirements and the pay equity provisions. What that really means is that, to quote from the language, if a third-party client leases or contracts with a temporary help service firm for services of a temporary worker in a designated classification, the third-party client shall be jointly and severally responsible for any violation of this section. Now, the troubling thing about that is we've seen these arguments being made in litigation. This is a statutory codification of a lot of those arguments that the plaintiff's bar has been making, that both the temporary service firm should be responsible and the ultimate firm who has the worker should be responsible as well. Another important thing to keep in mind is that a lot of times the relationships that exist between the temporary staffing agency and the end client is these relationships are driven by contract, and the contractual provisions, whether they provide for certain indemnification provisions or any type of other responsibilities, really need to be scrutinized at this point in light of this law to really make sure that the requirements, obligations, indemnification provisions, all these fall in line with what the new New Jersey law requires. Ultimately, these contractual provisions may exceed what the law permits, or rather, portions of them may be prohibited as far as how responsibility is assigned and what contractual provisions can offer. I will note that in other contexts, New Jersey is a blue pencil state, so for those who litigate contractual provisions like this, courts do have the ability to effectively retroactively rewrite what a contract will require. However, that as a fallback plan is not necessarily a great place to be. If we have the opportunity to review a contract, to really think through what these contracts provide, that is certainly in a, placing us in a much better position. Another thing, because of the analyses that are required with, scrutinizing whether the work is substantially similar requires a similar skill set or anything along those lines. That is a really important aspect of what this law requires, thereby necessarily making it very important to review the job descriptions and the actual tasks that are being performed by the workers. Now, I say the word actual tasks intentionally because a lot of times, to the extent that there can be a disconnect between what a written job description is on paper and what the day-to-day actually entails, a lot of times what drives litigation and drives these compliance conversations is the tasks that are actually being performed, the tasks that are actually being done on a day-to-day basis. And to some extent that could differ from what's in a written job description. Over time, that job description or that role may evolve. Those analyses have to happen on an ongoing basis. Next slide, please. So if we can talk a little bit about a couple of aspects of the law, another very critical and noteworthy provision in this law is the anti-retaliation provision. Now, I will say that the anti-retaliation concept is certainly not unique to this law, but what is unique is that if a worker engages in a protected activity, and we'll talk about that in a second, and there is any type of adverse employment action, for example, the worker is taken off the placement or effectively terminated, within 90 days of that protected activity, there is a rebuttable presumption that adverse employment action was retaliatory. That is a major, major, major red flag in this law that folks need to pay attention to. That rebuttable presumption effectively says it is retaliation unless the staffing agency or the employer can prove that it is not. That is not a insignificant hurdle. It's not, to some extent, it's not a new requirement in that oftentimes when dealing with the Department of Labor or other agencies, even in litigation, oftentimes the focus tends to be on requiring the employer to prove that there was no discrimination, there was no retaliation, as opposed to affirmatively looking to put that burden on the employee after the initial pleadings are established. So it kind of flips on itself in the analysis. In practice, here we have a statutory rebuttable presumption, so it's not impossible, but it is certainly a much taller mountain to climb in New Jersey than in a lot of other contexts, even comparing to the McDonnell-Douglas test or something like that. So one of the things that is really critical to understand is that what are those protected activities? So protected activities under this law could be something like an employee filing a complaint about a violation of any aspect of this law. Presumably, if an employer were to file a complaint that does not impact this law or does not implicate this law, for example, if it was unrelated to what's required in this law, it may not trigger this retaliation obligation. However, if there's any aspect of this law, the notice provision, the deductions, I would say that if there's any type of question or complaint or issue that's being brought up by an employee, that triggers our obligation to perform an anti-retaliation analysis if there's going to be any type of adverse employment action. Another one is filing a complaint. So not just complaining internally, but an external complaint. Somebody goes to the Department of Labor, somebody files a lawsuit. Critically important that for 90 days of that happening, there is this rebuttable presumption. Now, I should point out that I talk about a 90-day rebuttable presumption probably going to exceed 90 days because on the 91st day, that employee may still argue that there's retaliation. The analysis technically might be a little different, but that does not mean just a 90-day window on retaliation claims. Another thing that could be considered a protected activity is testifying or acting as a witness to anybody or any proceeding that's happening. So if there's a lawsuit and a worker serves as a witness, that would be a protected activity. If the Department of Labor has an investigation going, starts contacting employees to talk to them about what's happening in the workplace, that might be a protected activity. Any adverse employment action that happens really has to look at whether or not that employee engaged in any protected activity up until that time. Critically important provision. With respect to penalties, let's talk a little bit about the notice provision. So a penalty of the notice provision is subject to a civil penalty of not less than $500 and anywhere from $500 to $1,000 for each violation. Any penalty associated with the itemized statement that needs to be provided to employee, again, between 500 or within $500 for the violation, and the civil penalty shall increase to $2,500 for a second or subsequent violation. So $500 for the first, $2,500 thereafter. The other thing that's important about this law is that a failure by a third-party client to maintain or remit time records may subject the third-party client to a civil penalty of up to $500 for each violation that is found. Now, what's really important to note is that the law does not just provide for civil penalties. The law does talk about explicitly providing for individuals to bring civil action in court. Again, 6-year statute of limitations. An employee would be able to file a civil action in Superior Court, New Jersey, or federal court if that would be allowed. Also, there is a express clause that allows for representative action. So any type of class action would also be permitted under this law as well. So as we talk about these penalties and we talk about what's required under the law, it is critical to understand how these connect and interrelate. A penalty of $500 to $1,000 sounds relatively manageable, perhaps. However, extrapolated to X amount of employees, X amount of placements, X amount of, sometimes these penalties are calculated on a per day basis. Those add up quickly. The New Jersey legislature, Governor Murphy, Department of Labor, are all seeking to engage in robust enforcement of a lot of these provisions, not insignificant. So with that, I'm going to turn this over to my colleague, Nick, to take us through some of the frequently asked questions and some of the other information that we need to know. Nick, take it away.
Thanks, Rob. Yeah, and just to piggyback off that point, one of the things people ask quite a bit is, okay, so how do we get the third-party clients to remit information to us? And one of the things you can do is, to Rob's point, remind them that there are third-party client penalties involved in the law. They have an interest in actually remitting. And, we understand sometimes the relationships are a little bit different, but I think a light reminder that there are third-party client penalties in the law is a nice step in the direction of getting them to give you accurate and remit information to you. So big dates coming up, or the big date, August 5th, 2023. Obviously, we know notice retaliation already in force, but things are coming down. The rest of the law is coming. We are now almost, getting up to, I guess, a month and a half away. So things are gearing up quickly. Do you need to use the state's notice form? That comes up a lot. The wording at the top said must, and the FAQs on the website, which again, I encourage everybody to go read, say yes, you need to use their notice form. Regulations, I have made several communications, or attempted to communicate with the New Jersey Department of Labor. Anyone like me who has tried to make their way through the phone system knows that it's quite difficult, but it is unclear about the regulations. And we've had quite a few questions about the pending litigation, the pending lawsuit, District New Jersey, that Rob mentioned earlier. As of my knowledge at this moment, the motion to dismiss has not been filed, but we will be tracking that, providing updates as necessary. Moving to the next slide. And so one thing I definitely want to flag. This is an incorrect proposition below. There is a lot of misinformation out there, including on popular legal search engines. And I just want people to be aware. You see, it says effective August 2nd. That's not correct. Effective August 5th. That is the correct date. So just be aware that there is misinformation out there. Please get in touch with us if you have any questions. And also, the New Jersey Department of Labor, we get the sense, is trying to figure this out just as much as anybody else. And the FAQs, if you go through them, sort of hint as much. They are seemingly trying to figure out what the legislature said with respect to some of the notice provisions, specifically the name and nature of the work and the description of the job. New Jersey Department of Labor in responses, they assume that there are two different things. So they're still trying to figure it out as well. And so we anticipate further guidance and regulation forthcoming. I want to turn it over now to Ben, who's going to be talking about the benefits portion of this law.
Thanks, Nick. And I'm going to spend maybe the next 5 minutes talking about benefits. And I know that many of you hear that and think, great, this is the time for my bathroom break. That's fine. I've been doing this a long time and I have no dignity remaining, but just make sure you're back in 5 minutes because Marlon's going to have a barn burner of a presentation here. So look, when we talk about the benefits, I think that there are more unanswered questions than known answers at this point. But the key here is that, and disregard my quotation marks because it's not exactly what the text says. What the text requires of the law is that a staffing agency must provide a temporary employee with the equivalent average cost of benefits as a substantially similar permanent counterpart at the client employer. Or, thankfully, although this is maybe bad for reasons we'll talk about in a moment, a cash equivalent payment, right? So it's a comparable benefits or cash requirement. The problem is when you're looking at comparable benefits, as those on the benefit side of the house know, I think there are two significant hurdles there. One is, what is comparable benefits, right? Are we talking about just medical and retirement? Are we talking about the entire array or plethora of benefits? I mean, you know, you've got things like commuter benefits. Many companies now have adoption assistance or surrogacy benefits or whatever the case might be. So how broadly is that term defined, right? What are we talking about when we are looking at this? So that's, I think, one piece. The other, I think, challenge in this space is that, and I saw somebody ask a question about this, even when you focus in narrowly on something like health insurance, what we know is that most organizations have different tiers of benefits available, right? You may have your lower value, high deductible health plan, higher value PPO, higher value even EPO, of which those are three different financial equivalents. And then within each of those categories, you probably have different tiers of coverage level, right? Employee only, employee plus spouse, dependent, et cetera. And then when we're looking at sort of what's an equivalent, there are a lot of nuanced factors associated with benefits plans that could influence the value of the benefit for that specific individual. So many plans have waiting periods, right? And if a substantially similar employee has a waiting period, if they're a permanent employee, should it not be commensurate for a temporary worker who's placed at that organization, because that influences the value of the benefit for the individual. Also, when you look at things like retirement plans, you have nuanced provisions like vesting schedules associated with matching contributions or last day of the year requirement associated with earning that benefit that certainly impacts the value of those benefits and makes it challenging to implement. So that's the first big hurdle is, what do we mean when we say equivalent average cost of benefits? Is it theoretical average cost if the employee took advantage of every single thing available to them? Can you pick one specific worker at the organization and look at their package specifically, you know, the total rewards package, and focus on that? We don't know, but most of this will hopefully be fleshed out in regulatory guidance forthcoming. So the other big hurdle in this context is, even if I wanted to pursue that avenue of giving equivalent benefits to this individual, how do I accomplish that, right? Because as we know, staffing agency benefit plans aren't structured to customize per individual based on what's required for that specific individual, based on where that individual is placed. And any given person working for a staffing agency could be at 3 or 4 different organizations over the course of the, or more, right, over the course of the year. So no one's benefit plan is structured to say, you know, your benefit level is going to ebb and flow over the course of the year based on your specific conditions. For a variety of reasons, administrative limitations, non-discrimination concerns, et cetera. So I think it's going to make it incredibly hard to try and go the benefits avenue. If you did, and again, this is equivalent average cost of benefits, so you could pick a bucket that exists within your organization and apply everything to that bucket. So for instance, if you have health insurance already, and maybe you have a health reimbursement account, which is really just sort of a notional cash bucket, if you will, that can be tapped into to reimburse for unreimbursed healthcare costs. that's something that you could sort of just, raise or lower based on what's needed for that specific individual. But again, the thing is, we don't even know if that would work, right? Because HRAs aren't guaranteed payments to the individual. It's contingent on them incurring healthcare expenses. So we think that most people are going to trend towards the cash equivalent in lieu of the benefits cost. But that's the big unanswered question here. We talked a lot about substantially similar employee earlier in the presentation. Rob covered that, so I'm going to talk about that. The other big question I think that merits consideration here is, well, look, ERISA governs employer plans. Shouldn't ERISA preempt application of this law with respect to employees working for a staffing agency? The answer there is maybe, but I'm not terribly optimistic. And the reason why is that even though we appreciate that they added the language in that said, well, look, you can either give them benefits or the cash equivalent, what we've seen time and again is that the Supreme Court has looked at similar type, pay or play requirements and ruled that because of that cash equivalent avenue, that doesn't actually dictate the benefit design of the staffing agency. And as a result, ERISA preemption wouldn't apply. I mean, look no further than San Francisco's healthcare ordinance, which has a cash equivalent, right? Or Seattle's hotel mandate, or various other types of laws that have been structured specifically with this modify your benefit plan or just pay additional cash. And generally speaking, the courts have found that that's enough to avoid ERISA preemption. So while we're sure that there will be challenges filed in that regard, we're just not terribly optimistic that they would be successful. So with that, I'm going to flip to the next slide and turn it over to Marlon to talk a little bit about leave considerations.
Thanks very much, Ben. So I'm going to be giving an overview of the New Jersey earned sick leave law, as well as touching upon some of the wrinkles that are specific to temporary workers, as well as discuss some of the interplay between the New Jersey earned sick leave law and the New Jersey temporary workers bill. So the New Jersey earned sick leave law has been in effect for a while now. It went into effect in October of 2018. And the first thing we have to look at is whether this law even applies to you. So I see some people in the question saying, how does this affect New York employers? So for this, we have to look and see if you're a covered employer under this law. Under the law, employer is very broadly defined, and it means any person, firm, business, or other entity that employs employees in the state, including temporary health service firms. So unlike most laws that don't specifically address temporary health service firms in their employer coverage definition, New Jersey makes it clear that temporary health service firms are included. And it defines a temporary health service firm as any person who operates a business which consists of employing individuals, either directly or indirectly, for the purpose of assigning those individuals to assist the firm's customers in handling various types of work. So very broad there. Then we have to look and see if any of your employees are covered. So there's no express employee eligibility standard under the New Jersey earned sick leave law. However, the law's definition is very broad, and it basically includes all employees who work for an employer in New Jersey. So for those who asked about New York employers, if you do have employees who work in New Jersey, they would be covered employees under this law. If we look over to the next slide, just as an overview, so employees have to start earning sick leave upon commencement of employment, so there can't be a probationary period in order to have employees start accruing leave. They have to accrue as of day one. And they accrue leave at the rate of 1 hour of sick leave for every 30 hours worked, up to 40 hours of paid sick leave in a benefit year. So one thing that the law specifically calls out in connection with temporary health service firms is that employees accrue time on the basis of the total amount of time worked on assignment with a temporary health service firm, and not separately for each client firm to which the employee is assigned. So in calculating their hours, just make sure that you are counting all of their assignments and making sure they're accruing time for all of their assignments rather than for each specific client separately. So if employees have unused accrued time left over at the end of the year, you have to allow them to carry over up to 40 hours to the following year, unless you pay out the time in accordance with the requirements of the New Jersey law. Now, some of you who have operations in other states might be used to granting a lump sum grants of 40 hours of paid sick leave to employees at the start of the year and avoiding carryover. But in New Jersey, you can't do that, unfortunately. So even if you front load the time at the start of the year, make sure you're allowing employees to carry over up to 40 hours to the following year. But regardless of how much time employees carry over, they can only use up to 40 hours in 1 year. So you can definitely set that limitation. Now, the law also has a usage waiting period. So if you've been seeing a lot of the new paid sick leave laws that have come out, they say that employees can use leave on day one, but New Jersey actually lets you set a usage waiting period, so employees can use leave starting on their 120th calendar day after the employee commences employment. And this is especially critical for temporary employees who may have an assignment that's less than 120 days. So let's say you have an employee who is on an assignment for 90 days and then is separated from employment and then comes back to work on a different assignment later. So that employee will have to be reinstated any leave that they accrued on that first assignment if they are rehired within 6 months of the time that they were separated. So if that employee enters a 90-day assignment, comes back within a month, you'll have to reinstate the time that they previously had accrued, and the 90 days that they had previously worked will count toward that 120th calendar day usage waiting period. So it's important to remember this for employees who have shorter assignments, that they do get the benefit of the time that they accrued and of the time worked previously. Next slide, please. So in this slide, I just want to remind you of the reasons for use and the covered family members under the law. So you will get the slides later and you can review this more closely, but essentially employees can use leave in connection with their own or a family member diagnosis, care, treatment, recovery from a physical illness, injury, or other adverse health condition, as well as preventative medical care. Employees can also use leave for certain absences relating to the employee or family member being a victim of domestic or sexual violence. They can use it for certain absences related to public health emergencies, including COVID, but also beyond COVID, as well as in connection with certain school-related conferences and meetings about care for their child's health condition or disability. So as you can see, there are 11 different categories of covered family members. Again, I'm not going to read through all of those, but there are a couple that I want to point out to you. Number 6, civil union partner. This is not a covered family member that we typically see in other sick leave laws, so I just want to point that out to you that they are covered in New Jersey. And the other one I want to point out, although this has become very common among paid sick leave laws, is number 11, which is the sort of catch-all family member of any other individual related by blood to the employee or whose close association with the employee is the equivalent of a family relationship. Next slide. So now I'm going to talk about some of the interplay between the New Jersey Earned Sick Leave Law and the Temporary Workers Law. But before I do that, for those of you who have to jump on a 1 p.m. call, I want to read out the CLE code. So the CLE code is SS as in Seyfarth Shaw 6421. Again, it is SS as in Seyfarth Shaw 6421. SS 6421. Now I'm going to talk to you about notice. So the New Jersey Paid Sick Leave Law has a notice and posting requirement. Specifically, it requires that at the time of the employee's hire, as well as at any time requested by the employee, employers provide employees with a notice that provides them with certain information about their rights under the sick leave law, specifically their rights under the law, including the amount of leave that they're entitled to, the terms of its use, and the remedies provided by the law. this also has to be posted. Now, New Jersey temporary workers law, as Rob mentioned earlier, also requires that notice be provided to employees upon dispatch, and that also has to include the amount of sick leave to which temporary workers are entitled to. So make sure you're providing both of those. And then on the last slide, I just want to mention record keeping. So on the next slide, you're going to see that employees are required to keep records of certain information, including hours worked and amount paid. So if we could go to the next slide, please. And compensation for the employees for a period of 5 years. The New Jersey temporary workers law also has record keeping obligations, but and some of those records are similar, like the hours worked, the rate of pay, and the notices provided, but you have to keep them for 6 years rather than 5 years, so make sure you don't get rid of them prematurely. And with that, I just want to thank everybody for attending, and we will review your questions, and please feel free to reach out to Rob, Nick, Ben, or myself with any questions that you have. Thank you all.